Hello, hello, hello.
I request all the students to kindly remain seated and be silent as our guests will be arriving soon. Please put your mobile phones on silent mode. I request everyone to please rise as our guests are arriving. Please give our guests a big round of applause. We have with us Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India, accompanied by our Executive Director, Reverend Dr. Joshi Pudua, our Principal, Professor Dr. Mohanar Bolla, Assistant Executive Director, Reverend Father Tony Manikithan, Mr. P.S. Anthony, our Senior Faculty, Retired District and Sessions Judge. I request all the dignitaries to be kindly seated on the dais. It's a distinct honor and privilege for Bisols today to welcome our esteemed guest, Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India, a respected member of the judiciary whose unwavering commitment to justice, integrity, and the rule of law continues to inspire confidence in our legal system. He was a former Chief Justice of High Court of Rajasthan. Justice Sandeep Mehta enrolled as an advocate with the Bar Council of Rajasthan in 1986. He commenced his legal practice before the trial courts and Rajasthan High Court, primarily handling criminal and constitutional matters. Over the course of his distinguished career at the bar, he served as counsel for the commission in 3 judicial inquiry commissions headed by both sitting and retired judges of the Rajasthan High Court. He was an elected member of the Bar Council of Rajasthan from 2003 to 2009 and served as its vice chairman from 2004 to 2005. In 2010, he was elected chairman of the Bar Council of Rajasthan. Justice Mehta was appointed as an additional judge of the Rajasthan High Court in 2011. He was elevated as a permanent judge in 2013. In 2023, the Supreme Court Collegium recommended Justice Mehta to be elevated as a judge of the Supreme Court. We are very fortunate to have you here, sir. Let us begin this auspicious occasion by seeking the blessings of Almighty. I invite Ms. Shantini Kes, 6th semester Unitary LLB student, for the prayer.
There shall be showers of blessing. This is the promise of love. There shall be season refreshing. Send them a Savior above. Showers of blessing. Showers of blessings we need. Messages round us are falling, but for the showers we plead. There shall be showers of blessing. Send them upon us, alone. Grant us now a refreshing. Come on now, honor the word. Showers of blessing. Showers of blessings we need. Messages round us are falling, but for the showers we plead.
Thank you, Shantini. A mentor and guiding force of our institution, our principal has always inspired us with vision and dedication. May I now invite Professor Dr. Mohan R. Bolla for the welcome address. Sir, please.
Sabha Saraswatyai Namaha. Honorable Justice Sandeep Mehta ji, Reverend Dr. Joshi Putua, Reverend Father Tony, Sri Anthony, learned faculty brethren, and most lovely students of Bharatamata School of Legal Studies. Let us pay tributes to the holy great souls who have established and founded Bharatamata institutes leading to academic excellence. And one of the offshoots of Bharatamata mission of educational career building, including the legal studies, is Bharatamata School of Legal Studies. And today is a landmark historic occasion for Bharatamata School of Legal Studies to host the gracious presence and visit of Honorable Justice Sandeep Mehta sir. And these golden moments of gracious presence of Honorable Justice Sandeep Mehta transformed this institute into a temple of legal learning. And I appreciate each one of you for having contributed for that. And I take this opportunity to extend a warm red carpet welcome from the bottom of my heart to Honorable Justice Sandeep Mehta sir. Heartiest greetings and welcome to you, Honorable sir. And I request Reverend Dr. Joshi Butwa to offer a green welcome to Honorable Sir. My dear friends, as you are well aware, Honorable Sir started his career as a lawyer and a teacher, then transformed into and elevated as a justice. And being a fountain of justice, Honorable Sir's acumen and the wisdom in analyzing various judicial precedents and rendering justice has become a passion for reaching the outreached and disseminating justice to its logical but just ends. And today, Honorable Sir is here as a typical teacher whose enthusiasm always drives him to various institutes, and we are fortunately here to invite him, and with that dedication of being a teacher, Honorable Justice is a fountain of justice and a hero from Rajasthan High Courts, and Sir has been doing a wonderful job of rendering justice to and taking it to the doorsteps of the common man. Here also, on his very outset, he was talking about the legal aid and extension of legal literacy services to the poorest of the poor and to the adopted villages. That is the greatness of Honorable Sir, and let us all give a standing ovation to Honorable Sir and appreciate his gracious presence here. Please. Thank you very much, and please be seated. Now we have with us Reverend Dr. Joshi Butwa, whose commitment is in posting to the ideals of law schools. The Canadian Committee defined a law school as a law school is not only a teaching institution, but it is, or it should be, a research center of its own. A core of advanced faculty members and students continuously strive to have a stream of books, articles, enriching the legal literature. Besides training the men here, and women, ladies and gentlemen here, we have that mission of taking the justice to the doorsteps of the common man. With that mission, watching for it, here is the manifestation of such commitment, Dr. Joshi Butwa. I extend a warm welcome from the bottom of my heart, Reverend Father. Please accept that. Reverend Father Tony, a very young, matured and understanding financial administrator, an MBA in finance, and his maturity is evident in his face, and the dynamism will be exhibited very shortly as he got inducted very recently, and I appreciate his gracious presence here. Welcome to you, Father. Anthony Sir can be considered as the Bhishmacharya here on this campus. Kudos to your wisdom, Honorable Sir, and we welcome you. My dear faculty brethren, you are the strength and ability whose readiness to disseminate knowledge and undertake any program, and n number of programs will be organizing, and we continue to enrich the legal literature and ensure that global citizens of legal profession with all such dynamism will be our motto, and we enable our students to excel in all fields with our commitment to disseminate knowledge and The tools are none other than our student fraternity. Heartiest greetings and welcome to you here. Last but not the least, the most lovely students of Bharatamata School of Legal Studies. You are the inspiration, ability and strength which boosts our energies inside the classroom and outside the classroom. Your activities, curricular, co-curricular and extracurricular, would definitely enable us to initiate innovative programs and make this Bharatamata School of Legal Studies reaching very greater heights akin to the National Law Schools of India University all the time. And with that motto, we proceed further. And I take this opportunity to appreciate each one of you, the great souls and inspirers to the teaching fraternity. Heartiest greetings and welcome to you all. Regarding the theme we initiated today, and Honorable Justice is going to deliver an inspiring lecture on the Bharatiya Dandanyaya and the interface of technology. And we have been traversing from the days of pickpocketing to digital arrests. And the technology interface is so that now even the most modern legislations like BNS and BNSS doesn't have coining or defining a particular crime like digital arrest. And such wonderful phenomena which needs to be recognized will be cherished and will be appreciated, analyzed, and the need of the hour is to debate on various aspects of the crime and the interface of the technology. And we look forward to have a wonderful session ahead with the gracious presence of Honorable Justice Sandeep Mehta here. And extending my kudos once again, I take this opportunity to salute each one of the great souls. Heartiest greetings. Welcome.
Thank you so much, sir, for that warm welcome. We are also extremely honored to welcome you to this event, sir. The lighting of lamp signifies the dispelling of ignorance and the pursuit of knowledge and truth. I request all the dignitaries to kindly come forward for lighting the lamp. It's my proud privilege to invite Honorable Mr. Justice Sandeep Mehta to deliver the lecture on Indian Criminal Justice System and Interface of Technology, Bharatiya Dandanyaya. With vast experience on the bench and deep insight into the law, we look forward to an enlightening and enriching session. So please.
very warm good morning to all. I wish everyone present in this grand auditorium of the Bharat Mata School of Legal Studies a wonderful festival of colors our country is celebrating. Happy Holi to all of you. Dr. Joshi, Father Dr. Joshi, the Executive Director of BSOLS, Professor Dr. Mohan Bola, Principal, Bharat Mata School of Legal Studies, Father Tony, Assistant Executive Director, Mr. P.S. Anthony, Senior Faculty, Bharat Mata School of Legal Studies, esteemed faculty members, and above all, my dear students and the budding lawyers of this justice delivery system. Before I commence my address on the topic which is the theme of discussion today, I must acknowledge and appreciate this remarkable institution. We had a tour of the entire institution and also interacted with some of the bright students. The very impressive entrance with the grand NCC salute was truly moving. The cadets displayed the efficiency and the professional skills of no less than the paramilitary forces of this country. I'm sure that with this training, their life will be full of discipline and inspiration. The infrastructure of this institution has also impressed me to a great extent. The credit, my friends, must go to the founders of this institution, their vision, the spark which I saw in the students is a credit to the learned faculty members. I'm truly impressed that I was told that there are 50 highly qualified faculty members who are imparting knowledge to no less than about 1,600 students who are studying various streams of law in this institution. This again speaks volumes about the vision of the school management. I congratulate each one of you for this remarkable achievement. The topic of today's discourse, criminal justice system and interface of technology, could not have been more contemporary. This is something which has opened a new frontier and has changed the very perspective in which we knew the traditional justice delivery system. Friends, criminal jurisprudence has long been described as the sharpest instrument of state power. It authorizes the state to investigate, prosecute, and where guilt is established, to deprive the individual of personal liberty. Technology, in the meantime, has emerged as a most transformative force of our age. It has reshaped communication, commerce, governance, and lately, identity itself. When these two forces converge, that is the coercive state power and the technological capability, put it a little back. The legal system is compelled to re-examine its deepest assumptions about crime, evidence, privacy, due process, and punishment. I am audible to all? Okay, I don't need this mic as a matter of fact. India's criminal justice system has long struggled with systemic challenges. Everyone knows procedural delays, case backlogs, limited access to justice, and investigative inefficiencies. Over the last 2 decades, technological innovation has emerged not merely as an administrative convenience, but as a reform strategy, one that promises efficiency, transparency, accountability, and broader access to justice. Yet, we must be clear, efficiency cannot be the constitutional endpoint of law. Justice must remain accessible to everyone, even the one who does not have access to this technology. The story of criminal jurisprudence and technology in India is therefore not a story of gadgets, but of institutional transformation operating within the constitutional limits, with the goal being to reach the last man standing. Technology today is not merely an external tool used by law enforcement of courts. It has become an environment within which crime occurs, evidence is generated, and justice is administered. The digital footprint of an individual may at times speak louder than the eyewitness testimony. Algorithms influence investigative prioritization. Virtual courtrooms are no longer extraordinary arrangements, but in many instances, necessary mechanisms of access. When I was taking a college tour, I was told that large number of the classrooms have been transformed into digital display systems so that all the students can have access to this discourse. That is what change means. This transformation compels us to ask whether criminal jurisprudence can evolve in a manner that preserves fairness, clarity, and restraint while embracing technological progress. The Constitution, my friends, demands that any procedure established by law under Article 21 must be just, fair, and reasonable, as was held by the Supreme Court way back in the year 1978 in the case of Maneka Gandhi. That principle applies with equal force in the present digital age. Technology has not only drastically changed the process of law, but has led to emergence of new tools, avenues, methods, and procedures which have reshaped the contours in which we define the very basis of a crime. The justice system is therefore at crossroads. Criminal jurisprudence, as you may have studied, has always been shaped by the social and material conditions of its time. The nature of crime, methods of investigation, forms of evidence, and the structure of adjudication have reflected prevailing realities. As Professor Bola said, from the age of petty pickpocketing, now we have come to the age of digital arrests and massive fraud. In our present era, technology has emerged as the single most influential force, reshaping each of these dimensions simultaneously. Crime today is no longer confined to physical spaces or direct human interaction. It may be committed, or rather it is being committed remotely, instantaneously, and at a scale. Evidence may exist entirely in digital form. Investigations increasingly rely upon technological tools rather than traditional modes of inquiry. Courts are required to interpret conduct that unfolds within virtual environments using legal doctrines developed in an analog world. A small example I will share with you. Just a few days back, we were considering the bail application of cyber fraud. the accused had been arrested in a single case and his participation had been traced by certain banking transactions and call logs. But when the investigating agencies tried to trace the involvement of the particular mobile number or the emails, then it came to light that the same footprint was involved in no less than 200 similar kinds of cyber fraud, and it was spanning all over the country. This transformation, therefore, requires the criminal jurisprudence to undergo a process of conceptual recalibration by not abandoning its foundational principles, but adapting them to new forms of conduct, proof, and responsibility. The challenge is, therefore, to ensure that the legal system remains effective in addressing the modern crime while preserving clarity, fairness, and institutional legitimacy. For much of its history, the criminal justice system in India has operated on the assumption that the crime would leave physical traces or footprints, bodies, weapons, fingerprints, documents, eyewitnesses, or similar kind of documentary or ocular testimony. Criminal procedure heavily relied upon paper records, in-person hearings, and geographically localized investigations. The Indian Evidence Act was structured around tangible objects and oral testimony. I'll again share one incident where technology completely changed the outcome of a case. There was a matter which came up before us in the Rajasthan High Court. It was an incident of murder, a crime of murder. The trial court acquitted the accused only on the ground that the doctor who conducted the post-mortem report on the body could not be traced out, and his evidence was naturally not recorded. This was in pre-COVID times. COVID, of course, changed the entire way in which we visualize the justice delivery system with virtual hearings, virtual evidence recording. We tried to look up into the records, and there was a trace of that doctor's email in the charge sheet. So we called the investigating officer in the court and asked him to trace the doctor through the email record. Finally, it was found that the doctor, who was a trainee, a probationer in the hospital at that particular point of time, had moved to a distant location. He was contacted, and in those days, I am speaking of 2018, the evidence of the doctor was recorded virtually. That led to the conviction of the accused. So, the challenge, therefore, is to ensure that the legal system remains effective in addressing modern crime while preserving clarity, fairness, and institutional legitimacy. The system's initial engagement with technology was administrative rather than doctrinal. Computers replaced registers. We have seen the times of the Remington typewriters to dot matrix printers, and later on computers. And now, of course, you do everything on the laptop or even the mobile. Databases supplemented manual records, communication accelerated. These changes improved efficiency but did not alter the conceptual structure of criminal law. The acceleration of communication, there has been a remarkable development. I will request the faculty members as well as the students to have a look into the e-prison system which has been developed by the NIC under the ICJS. The system has changed the way in which we procure the records of prisoners. In traditional justice delivery system, procuring the custody certificate of a prisoner would require manual communication with the prison authorities. Thereafter, calculations to be made in the prisons of the custody period the convict had suffered. The communication through traditional modes, that is letters, that could have taken, or rather that took months to ensure that the custody certificate reached the court. Now, in the e-prison system, which has now recently been developed, you get all these details and much more than that at the click of the cursor. That is the remarkable change which technology has brought. The advent of widespread internet access, mobile devices, and the digital transactions have marked a turning point. But at the same time, crime began to exploit the same technologies that were transforming commerce, communication, and governance. Fraud, as everyone knows, has migrated online. Identities have become digital. Now we have the electronic signatures, the doing away with the requirement of a physical signature. Fraud has really transcended into the lives of all citizens. It is a great threat. Criminal coordination has transcended territorial boundaries. The justice system was compelled to confront the forms of wrongdoing that did not fit neatly into the existing legal categories. This transformation has exposed the limitation of the existing justice delivery system, calling for incremental reform and underscoring the need for systemic adaptation in substantive law, more importantly, procedural law, and the manner in which we perceive evidence. Technology has not merely created new offenses, it has altered the very structure of criminal conduct. Many contemporary offenses, as we know, are characterized by absence of physical proximity between the offender and the victim, use of automated or semi-automated systems, reliance on digital anonymity. VPNs are used, you can't trace the criminal. Repetition and scalability, transnational reach. Now that is really very dangerous. Acts such as online fraud, ransomware attack, data theft, digital extortion, and unauthorized system access are being executed with minimum physical effort, yet they cause widespread damage. The scalability of digital misconduct is challenging the traditional assumptions regarding preparation, attempt, and completion. You might be knowing that there are villages, some in Jharkhand, some in Rajasthan, which have now replaced that concept that all these online frauds emanated from some African countries. In these villages, as we have experienced while dealing with cases of cyber fraud, young boys, 14 years, 15 years old, who are totally illiterate, not having any qualification, they are masterminds. They have mastered this technology and are indulging in rampant cyber fraud. It's a challenge to this these young legal mind, how to challenge these or how to deal with this magnitude of cybercrime. Now, technology has done one more thing. It blurs the distinction between individual wrongdoing and organized criminal activity. In one single cyber fraud, the traces may go out to across borders. Number of persons involved. The bank account is emptied by a digital arrest, and moments later, the funds are transferred to different entities and identities. Digital platforms enable loosely affiliated actors to participate in coordinated schemes without formal hierarchies. Criminal jurisprudence in a technological society is therefore grappling with new questions of attribution, participation, and collective liability. Technology has altered the very meaning of criminal harm. Traditionally, as everyone knows, crime was understood as a physical act producing direct and observable harm. There was tangible evidence to prove a crime. In the digital age, criminality increasingly manifests through manipulated information, automated deception, and synthetic identities, often without physical presence or immediate visibility. One significant development is the use of deep fake technology, which permits fabrication of realistic but false audio and video content. Such technology has been misused for financial fraud, extortion, and reputational harm, most notably through fabricated communications impersonating corporate executives or private individuals to induce financial transfers or coerce victims into yielding. Here, the criminal act lies in the deliberate construction of a false digital reality. Artificial intelligence has similarly transformed fraud and deception. AI generated voice cloning and automated phishing campaigns allow the offenders to scale criminal activity with minimal effort. Victims may be deceived by communications, such communications which convincingly mimic trusted voices. They may even mimic the voice of a parent, a brother, a sibling, a sister, wife, and you are absolutely unaware who is calling you. And this is so even when the offender never directly interacts with the victims. The injury unfolds over time, often invisibly. The technology has also weakened the traditional links between crime and physical proximity. A single individual may now cause, or rather is causing, widespread financial or informational harm. With remote access, the injury unfolds over time and across jurisdictions. That is yet another challenge because the crime has taken place over so many jurisdictions that you are baffled where the list would lie. In such situations, crime appears less as a single identifiable event and more as a continuing process driven by technological misuse. The harm may be cumulative, diffused, and temporally extended rather than being immediate and localized. These developments challenge conventional distinctions between preparation and commission, individual and collective responsibility, and tangible and intangible harm. As digital tools continue to evolve, criminal jurisprudence must respond to forms of wrongdoing that are less visible yet equally injurious. It must ensure that emerging technologies do not create spaces where accountability becomes uncertain or diluted. Modern criminal law increasingly recognizes that traditional offense definitions must be adapted to capture technologically enabled conduct. Legislatures, my friends, have responded by explicitly including digital acts within offense description. IT Act, Section 65B, these are the examples of how legislature has responded, creating new categories of unlawful activity that reflect patterns of repeated or coordinated conduct, recognizing electronic communication as a medium through which criminal liability may arise. One significant development has been the emphasis on continuing or sustained unlawful activity. This development acknowledges that certain forms of crime, particularly those facilitated by technology, are not isolated events but prolonged operations involving multiple acts over time.
Pardon me, the Lance says that it is not audio. Can not audio. I said it.
Okay. However, the expansion of criminal liability, am I audible now? Okay. The expansion of criminal liability into digital spaces necessitates precision. Vaguely or overly broad terms risk uncertainty in application and inconsistent enforcement. Substantive criminal law must therefore balance flexibility with definitional clarity, ensuring that individuals can reasonably foresee the legal consequences of their conduct. Friends, criminal procedure has undergone one of the most visible transformations through technology. The best example is digital courts and case management. Electronic filing systems, digital case records, and online access to judicial information have streamlined court administration. These systems reduce dependency on physical files, improve coordination amongst institutions, and allow real-time monitoring of case progress. You must all be aware, you are using tools such as Supreme Today AI. Now, in our days of traditional litigation, we had to wait for days or weeks to get access to a latest Supreme Court judgment. Now that is completely transformed. The judgment is pronounced, it is uploaded, and it is available on your mobile phone within minutes. It doesn't even take hours now. Video conferencing has emerged as a significant procedural innovation. It enables remote hearings, a recording of evidence. Just I referred that what we did even prior to this era of this video technology. An interaction with incarcerated individuals without requiring physical transportation. This has become a very important tool. There was a big challenge in bringing the under trials to the courts. As everyone knows, that presence of the accused who is in custody is essential during recording of evidence. So every accused had to be physically brought to the court for marking attendance. Now, slowly but surely, that is changing. The attendance of the accused is being recorded through video conferencing facilities. This has reduced logistical burdens and improved efficiency, particularly in the preliminary and procedural stages. At the same time, digital procedures demand safeguards to ensure that parties can efficiently and effectively participate. Records are securely maintained. Now this is a big challenge. Every day you keep on reading that AI-generated judgments which never exist are being cited before courts. This is a huge challenge. Technological failures do not compromise fairness. Just now the light went off and I was not audible to the last part of the audience. So technological failures should not compromise fairness. The advancement of technology not only expands how we collect and appreciate evidence, but also what may constitute as evidence. One of the examples is courts allowing taking voice samples of the criminals. The investigative agencies increasingly rely on digital tools to collect, store, and analyze information. These include electronic database of criminal records, digital mapping of crime patterns, forensic extraction tools for electronic devices, automated analysis of financial and communication data. Now, these are very, very important developments. How do you get familiarized with what is happening in this field? I would suggest and request the faculty members and the management that it must be ensured, it can be found out from the district courts that whenever the evidence of an investigating officer who has collected electronic evidence is being recorded in the court, there should be a group of students to observe that recording of evidence. That would be the best way in which you can understand the nuances of electronic evidence. How the investigating officer collected the evidence, how he proves it, and how the defense counsel tries to demolish it. Such tools enhance investigative reach and speed, particularly in cases involving large volumes of data. However, their effective use depends on accurate data entry, inter-agency interoperability, and, of course, skilled personnel capable of interpreting technological outputs. Prosecutors must also adapt, developing expertise in presenting digital evidence, understanding forensic reports, and in addressing technical challenges raised during trial. Now, this development of e-filing system and virtual courts has given a great advantage to the judges and lawyers. How? It's really a pleasant and a really very useful tool, because what was the traditional way of looking at the files? The files running into thousands of pages are now available on the digital device. We don't need to access the physical files at all. In the Supreme Court, the files are really indexed very professionally. You can access page 1 to 5000 at the click of the button. That saves time, that makes the system more efficient, and of course, the accessibility is at every place. Now, while I'm traveling to Cochin, I'm having access to the files which may be listed before me on the next working day. So I don't need to go to my office for reading the files. Likewise, in hearing, most of the courts in the Supreme Court and now even in the High Court are having a completely paperless court. Kerala, my friends, I must acknowledge and appreciate, is the most advanced stage so far as digital courts are concerned. A big round of applause. And a large credit goes to two of my friends in the Kerala High Court. Now one of them is adorning the post of the Chief Justice of the Sikkim High Court, Justice Mohammad Mustaq and Justice Raja Vijayawardhan. They are the persons responsible for this remarkable change. So the advancement of technology not only expands how we collect and appreciate evidence, but also what may constitute evidence. What do the investigating agencies rely upon for collecting, storing, and analyzing information? These are electronic databases of criminal records, digital mappings of crime patterns, forensic extraction tools for electronic devices. Now what happens is criminals are one step ahead of investigating officers or the courts for that matter. They erase the traces, but now extraction tools are available that howsoever strong the erasure may be, they can always be retrieved. But of course that requires a lot of expertise. And one more example, automated analysis of financial and communication data. These tools enhance investigative reach and speed, particularly in cases involving large volumes of data. The recognition of electronic records as primary evidence marks a doctrinal shift in the law of proof. Electronic evidence encompasses a wide array of materials. It may be text messages, emails, online communications, call records, tower locations, digital transaction logs, location data generated by devices, photographs, videos, and audio recordings stored digitally. Most important, metadata revealing time, original, and modification history. These records often provide detailed, contemporaneous accounts of events and can corroborate or contradict testimonial evidence. However, digital evidence poses unique challenges. Unlike physical objects, it can be altered without leaving tangible traces. Its interpretation often requires specialized knowledge of systems, formats, and processes. It is at this place that this young generation stands at a great advantage. You are so technologically sound and advanced that we people who have passed through the rigors of the traditional legal system, we are far behind all of you. Procedural rules governing electronic evidence must emphasize certificate of origin, integrity of devices and systems, continuity of custody, expert validation where necessary. Despite doctrinal clarity, practical difficulties remain. Delays in forensic analysis, limited technical infrastructure, and shortages of trained experts can impede timely adjudication. Without adequate institutional capacity, the evidentiary promise of technology cannot be fully realized. Artificial intelligence poses yet another challenge. Artificial intelligence and data analytics represent the next frontier in criminal justice technology. AI systems can process vast databases to identify patterns, correlations, and anomalies. In criminal justice system, they may assist in prioritizing investigative leads, classifying evidence, managing large caseloads, identifying procedural inefficiencies. Used appropriately, such tools can augment human decision making and improve consistency. However, they come with their own risks and limitations. AI systems operate on data and algorithms that may reflect existing biases or errors. As I said, now artificial judgments are being generated. Over-reliance on automated outputs risk obscuring contextual nuances and undermine individualized assessment. The question that emerges here is the nature and extent of use of AI in the process of court. Honorable the Chief Justice of India, Justice Suryakant, and Honorable Justice Nagaratna have recently in judicial discourse noted and criticized the use of AI technology by the councils. They again referred to the citations, false citations being generated by using this process. Thus, AI must remain a supportive instrument, not a substitute for human judgment and skill. Legal stakeholders must be equipped to understand the assumptions and limitations underlying technological tools. Now, how technological reform aids and assists institutional capacity and infrastructure? And how can we use it? It would require more than a legislative change. It demands a sustained investment in institutions. Key requirements include modern forensic laboratories with adequate staffing, continuous training for judges, prosecutors, investigators, and advocates, of course, secure digital infrastructure for data storage and transmission. You see, cloud storage is very risky. As you know, hackers get into that. Likewise, the storage of judicial data is generally in dedicated servers, but the risks still exist. How to deal with that, that is a very big challenge. And finally, standardized protocols for evidence handling and technological use. Disparities in institutional capacities across regions risk creating uneven justice outcomes. Technology must therefore be accompanied by policies that ensure equitable implementation. What is the role of the judiciary in the background of this technological change? Judges, as everyone knows, occupy a central and yet a very delicate position in mediating between technological innovation and enduring legal principles. The courtroom is often the final arena where the claims of efficiency confront the demands of fairness. As technologically permeates investigation, evidence, and adjudication, it falls upon the judiciary to ensure that the innovation operates within constitutional boundaries. The judicial role is not to resist technological advancement, nor to embrace it uncritically, but to subject it to principled scrutiny consistent with the rule of law. In practical terms, this responsibility manifests in multiple ways. Courts must carefully assess the admissibility, authenticity, and evidentiary weight of electronic records. They must scrutinize investigative techniques involving digital surveillance, forensic extraction, and algorithmic analysis to ensure compliance with statutory safeguards and constitutional guarantees. Procedural innovations, whether virtual hearings, digital filings, or AI-assisted processes, must be evaluated and audited to ensure that they enhance rather than dilute effective participation and natural justice. For the judiciary to discharge this function effectively, continuous judicial education is indispensable. Technological literacy enables the judges to ask the right questions, appreciate the limitations of forensic tools, identify potential biases in the algorithmic systems, and engage meaningfully with expert testimony. Ultimately, the responsibility of the judge is to ensure that technology remains a servant of justice, never its master. Criminal jurisprudence, my friends, does not operate in isolation from the society it serves. The prevention of technologically enabled crime depends not only on effective investigation and prosecution, but equally on secure digital infrastructure, informed and vigilant users, and coordinated institutional responses. Robust cybersecurity frameworks, responsible data practices, and timely information sharing between agencies and stakeholders are essential components of a preventive legal ecosystem. Public awareness and cooperation between state, private sector, and civil society play a vital role in reducing vulnerability to digital fraud. Continuous adaptation of security measures, coupled with legal clarity and responsive enforcement, strengthens systemic resilience. The credibility of the justice system is ultimately reinforced when citizens are confident that contemporary technological threats can be addressed effectively, fairly, and within constitutional bounds. How can you contribute to this? I was just taken to the legal aid clinic and I posed the question to the faculty or the in charge faculty members as to whether the legal aid clinics, the outreach was being made to remote villages. That is what is being done in most of the national law universities. I would request you, all the students, to ensure that this opportunity which you get of participating in the legal aid clinics, reach out to the persons who are technologically illiterate. Advise them, warn them about these cyber frauds, instill the confidence in them, and make them literate technologically so that they do not fall prey to this threat of cyber fraud. This is a very important role which you can play under the legal aid system of this country. Now, what are the future challenges and the emerging trends? Friends, the pace of technological changes shows no sign of slowing. If anything, it continues to accelerate in ways that challenge the incremental nature of legal development. Criminal jurisprudence traditionally evolves through careful legislative drafting and judicial interpretation over time. Now you see the evolvement which has taken place over Section 65B. No, the earlier view being changed in Shafi Ahmad, then finally in Anwar PV, it was laid to rest. But whether it is still laid to rest, that is a question to ponder upon. Technology, however, evolves in cycles measured in months or even in weeks nowadays rather than decades. This divergence creates a structural tension. The law, therefore, must remain stable enough to ensure certainty, yet exhibit flexibility enough to remain relevant. The central challenge for the future will be to reconcile doctrinal continuity with technological disruption. One of the most emerging concerns is crime involving autonomous and self-learning systems. AI tools are increasingly capable of independent adaptation and decision making. If harm results from an autonomous system, whether in financial markets or automated infrastructure, or for that matter, digital communication platforms, the question of criminal liability would become really complex. Determining attribution, intent, and foreseeability in such cases will test traditional principles of mens rea and causation. The law will need to clarify how responsibility is distributed amongst designers, operators, beneficiaries, and users of such systems. The manipulation and exploitation of digital identities will also become more sophisticated as societies rely more heavily on biometric authentication, digital public infrastructure, and integrated data ecosystems. The vulnerabilities will expand correspondingly. Identity theft may no longer be confined to financial fraud, but may extend to electoral interference, reputational sabotage, and systemic misinformation. You keep on seeing these YouTube videos, AI-generated YouTube videos. They change your way of perceiving things. That is how the minds are being affected by AI-generated videos. Therefore, the legal system must anticipate threats not only to property and security, but to informational integrity and democratic stability. Finally, the exponential growth of electronic evidence presents both opportunity and strain. Future trials may involve vast quantities of digital material, communications, metadata, algorithmic logs, and device histories. The challenge will not merely concern admissibility, but the capacity of the institutions to process, analyze, and fairly evaluate such information. Criminal jurisprudence, therefore, must remain dynamic and anticipatory, supported by institutional agility, technological literacy, and sustained dialogue between legal and technological communities. As innovation advances, the safeguards of fairness, proportionality, and due process must advance with equal resolve. Technology in today's world has become inseparable from modern criminal justice. It shapes how crime is conceived, how it is committed, how it is investigated, how it is proved, and how it is adjudicated. Yet, we must never forget that technology is only an instrument. It is powerful, transformative, and at times disruptive, but it is not sovereign. The Constitution is and will always remain as the sovereign supreme power. The legitimacy of every technological innovation in the criminal process derives not from its efficiency or sophistication, but from its fidelity to constitutional values, fairness, proportionality, liberty, dignity, and above all, the rule of law. If technology accelerates justice but weakens due process, it diminishes the very system it seeks to improve. If it enhances investigative power but erodes personal liberty, it unsettles the constitutional balance that defines us as a democratic republic. The true strength of a justice system is not measured by the speed of its servers, the complexity of its algorithms, or the volume of its data. It is measured by its moral clarity, its institutional restraint, and its unwavering commitment to human dignity. To the students present here today, you belong to a generation that is more technologically fluent than any before it. You will practice law in courtrooms where digital evidence is routine, where artificial intelligence assists research, and where cross-border cybercrime is commonplace. But as you embrace these tools, do not surrender to them. Learn to question them, learn to understand their limits, learn to ask not only whether something can be done, whether it ought to be done. The future of criminal jurisprudence will not be determined by machines. It will be shaped by lawyers, scholars, and judges who possess both technological literacy and constitutional wisdom. Your responsibility will be to ensure that innovation does not outpace justice and that progress does not eclipse legal principles. In the moments of complexity, there will be many, I'm sure, return to the first principles, return to liberty, return to fairness, return to the Constitution. For in an age of rapid technological changes, it is not technology that must guide the law, it is the constitutional that reigns supreme. My sincere thanks to the management of the Bharat Mata School of Legal Sciences, Professor Mohan Bola, the faculty members, and the dear students for having given me this opportunity to be amongst you, to have witnessed a fantastic institution and the bright young students. I wish you great success in the pursuit of your careers. Thank you. Jai Hind.
Thank you so much, sir, for that insightful lecture. We shall now move on to the question and answer session. You may please introduce yourself before asking questions.
Good morning, sir. So my name is Mary Ann. So I want to ask you a question that how do you separate your personal belief from constitutional duty while you are deciding a difficult case? Okay. Okay. How do you separate your personal belief from constitutional duty while deciding a difficult case?
Personal
Beliefs. Personal.
beliefs. Okay.
Yeah.
So you're talking about moral conviction, right?
Yeah, yeah.
So my feeling is that moral conviction must never come in way of personal liberty. We have decided cases wherein we felt that the conviction of an individual was purely based on moral thinking, but that is totally an encroachment into personal liberty. This should never come in way of adjudication. Thank you.
Thank you.
Wonderful question. Must appreciate. Thank you.
Good morning, sir. My name is Rufaida. And my question is if you could share a most interesting case in your legal career.
So that would require an entire day. So I can't define one interesting case in this short time because there have been innumerable. But yes, since you've asked me a question, I'll tell you of an incident of a case which really moved me. And the response which I made, that was during my days as a lawyer. So it was a case involving dowry death. You see, when you start your careers as lawyers, my first advice to you, before I go on to answer your question, that your first 2 years must be spent in trial courts. Don't try to jump straight off into the bandwagon of high court practice. You must join the office of a good senior. Never think that since you have done your law from a very good institution, you can straight off start practicing individually. So join a very good senior. Do practice on the trial court side. And that too, though of course, I am guilty as charged, having practiced only on the criminal side mostly throughout my career. But my advice to all of you that look out for the office of a lawyer who is dealing in civil cases. That will broaden your perspectives, make you masters at appreciation of evidence and facts. And during your years of practice, you must learn the feature of empathy. So now I come back to your question. The case was of dowry death. I presume everyone knows what dowry death is? Okay. So the accused were the mother-in-law and the husband of the deceased. When you start practicing and you have joined the office of a good senior, you will observe that the senior would, before the case opens, have a client conference. Now, what is the importance of that? So, you interact with your client to find out what is the truth. Because what is presented in the court, generally, from the investigation side, is one view of the matter. That is the view of the prosecution, which wants the accused to be convicted. So I had that client interaction, and I realized that there was a substantial truth in the version of the defense that it was not a case of dowry death at all. The case was that the lady committed suicide at the ground floor of the matrimonial home. The husband had gone out to work. The mother-in-law was a disabled woman. She was paralyzed from back downward, the hips downwards. She couldn't move. She used to drag herself around for doing her day-to-day works. The deceased, she was living on the first floor, and the mother-in-law, because she was disabled, she was living on the ground floor. She committed suicide on the first floor of the building. The investigating officers, the police was informed. They came. The mother-in-law was available in the ground floor. She was taken from there. The body was found lying in the first floor or second floor, I'm not really sure now. It's being a long while. But anyhow, the prosecution started. I conducted the trial, and though I had a very good case after cross-examination of witnesses, but this situation captures the first question also. The judge who was dealing with the case was a known person of moral convictions. So in spite of there being no evidence at all, both the husband and the mother-in-law were convicted and were awarded life imprisonment. In my viewing, the mother-in-law was carried to the prison sitting on a chair, on a wheelchair. That was a very painful moment for me, because I knew from my own convictions that they had been wrongly punished. So on the very same day when the judgment was pronounced, I rushed to the High Court. I used to practice both on the trial courts as well as the High Courts. Rushed to the High Courts, made a mention to the judge. So there has been a conviction, and I want to file an appeal. You see, mentioning was done without even filing the appeal. So I had certain reputation in the High Court that when I made a request, it would be supported by a genuine cause. So the judge allowed the mention. The appeal was ordered to be listed on the next day. Next day in the morning, we filed the appeal without the judgment. It was listed, and I could secure bail for the lady without even the judgment being a part of the appeal. That gave me great satisfaction. So that is what the empathy every lawyer must carry. Legal profession is not only the means of earning money. My late uncle, he was a senior lawyer, and when I entered the profession, he gave me a small piece of advice. The advice was, and I'll share with all of you, that a lawyer has 4 phases in his life. The first phase is when the lawyer cares only about his client. So after the first phase, say 10 years or so, the lawyer starts caring about the client as well as the money. That would be, say, another 10-15 years. Then after 25 years, when the lawyer becomes very proficient, very popular, the lawyer cares only about money. And the 4th stage is when the lawyer claims about nothing. So I wish you all that you rise to the 2nd stage of your careers and never give up that stage. Always care for your client, because he is the one who provides you the bread and butter. Of course, you care for your money, but always spare some time and effort for pro bono work, for that is the greatest satisfaction for a lawyer to have provided services to the last man standing who doesn't even have the fare to go back to his home. So a large proportion, at least 25% of your practice must be dedicated to pro bono work. Thank you.
So, good morning, sir. First of all, my name is R. Gopalakrishna Shenai, and I would like to ask a question of law question, and it is based on the family law, that is prenums. What is the constitutional validity? The court. What is the status till now of the prenums in India? That prenuptial agreements.
But you are talking of more of a contractual law question.
Yeah. Yes.
So, all right, if it is a contractual law question, till date the courts in India have not recognized that.
Yes, sir.
So we work on the first principles. So that is, you are talking of a European concept or an American concept.
Yes,
so
sir.
prenup concept till date has not permeated into the Indian judicial system.
Sir, can we put forward a harmonious statute for that part of law
So
where
that would be for the legislature to answer, not for the judiciary.
Sir, my second question is about the grey area.
Give opportunity to your colleagues.
Okay, thank you,
You
sir.
had your one question answered. Thank you.
Okay.
Respected Your Lordship, I'm Fiza Ziad, a student of first year BBA LLB. With your permission, may I ask a question? So, traditional decision making is something that involves more than just interpretation of judicial law. So, it involves empathy, discretion, and a sense of understanding for.
See, discretion is not a part of judicial process, maybe at the initial stages. But discretion, grant of stay, injunction, bail. But ultimate adjudication, discretion hardly is relevant.
But shouldn't.
All right, you please complete your question.
Yes. So my question in this context is that should artificial intelligence ever assist in judicial interpretation, especially in
See,
decision making?
I think were you sleeping in my address?
Sorry?
Were you attentive in my address?
Yes.
I refer to that. Artificial intelligence may be a helper,
No.
that's all. It does not have any role in a judicial dispensation. It may be an assistive tool, that's all, nothing beyond that. Only assistive tool, research, and only organization of facts. That's all, nothing beyond that. Ultimate analysis, evaluation, you cannot rely upon artificial intelligence in any manner at all. Got the answer?
Okay. yeah.
Thank you. All right, last question, we suppose.
Good morning, sir. My name is Rijo Joni. I am unitary first year LLB. And my question is that, what is your opinion that the recent observation about the tapping of phones for phone is allowed for the divorce? Is it against the Article 14 and 21?
You make yourself clear. I couldn't hear what you are saying.
So the question is,
Keep the mic at a little distance. Yes.
phone tapping.
Phone tapping. All right.
For the divorce. So is it against the Article 14 and 21 and the right to privacy? So what is your opinion?
So, all right, phone tapping is a very sensitive issue which you have touched upon. In general perception, phone tapping is definitely an invasion into privacy. But if the agencies have a case of imminent breach or imminent threat to national security, perhaps the court may take a different view. So that's how thin the line is. So for national security reasons, the courts perhaps may put the concept of personal liberty aside when the issue of phone tapping arises. Thank you.
Thank you so much, sir, for that insightful and wonderful session. It's a privilege for us to mark our admiration and gratitude to Honorable Mr. Justice Sandeep Mehta for the valuable insights shared today. I invite our President, Professor Dr. Mohammed. Our Executive Director, Reverend Dr. Joshi Podua, to present a memento to our esteemed guests. I invite our Executive Director, Reverend Dr. Joshi Podua, to present a memento to our esteemed guest. I invite our Assistant Executive Director, Reverend Dr. Tony Manikathan, to present a small token of love. Every meaningful gathering concludes with words of gratitude. I invite Mr. P.S. Anthony, our senior faculty, retired district and sessions judge, for the vote of thanks. So please.
A very good morning to everyone. We are at the end of a beautiful and memorable event. Nyaya Sadvijara, an interactive session with the legal luminary program on Indian criminal justice system and interface of technology by His Lordship, Mr. Justice Sandeep Mehta, Judge, Supreme Court of India. Now it is my privilege to propose the vote of thanks to one and all who made this memorable event happen at Bharat School of Legal Studies. First, our immense gratitude to our chief guest, His Lordship, Honorable Mr. Justice Sandeep Mehta, for sharing such valuable insights on a very important and contemporary subject. I particularly appreciate your views regarding the interface of technology in Indian criminal justice system, which provide us all with a new perspective. As students of law, we know that traditionally we have oral evidence, circumstantial evidence, but as His Lordship has pointed out, now there is an exponential growth of digital evidence. Nowadays, more and more cases are decided on the basis of digital evidence. And we have to prepare ourselves to meet the technological challenges in our study of law and practice. We have studied that traditionally we have different theories of crime causation like biological theory, psychological theory, sociological theory. But now what is more important is technological theory of crime causation. It is not appeared in the textbooks. Our Lordship has now pointed out that, and we have to study from his speech. The digital evidence is becoming more and more important, and after the COVID-19, we know that there is increasing adoption of information and communication technology tools in the court management and court procedure, and virtual courts has emerged in India also. So it is a novel subject for all of you, and we are enlightened by his erudite speech. On behalf of the entire BSO LS family, I thank your Lordship for your inspiring legal discourse. Thank you, Your Honor. I would like to express our gratitude to our Executive Director, Reverend Father Dr. Joshi Pudua, for his constant guidance and for facilitating this program. As we know, he is taking every effort to lead this institution as a center of legal education. Thank you, dear Father. Thanks are due to Reverend Father Tony, our young and energetic Assistant Executive Director. Thank you, Father, for your valuable presence and support. I also express our heartfelt gratitude our Principal, Professor Dr. Mohan R. Balla, who is instrumental in getting the valuable presence of our esteemed chief guest today and enlightened all of us. Thank you, dear sir. I would like to take this opportunity to extend our thanks to the organizing committee, the technical team, the NCC unit, which has particularly impressed His Lordship, and our student volunteers who ensured the smooth coordination of this memorable event in our institution. I would like to thank all the members of the faculty and the non-teaching staff for making these events very successful. I would like to thank the media personnel for covering these events. And lastly, our dear students, it is your valuable presence and rapt attention you have paid to this inspiring talk that is the most important feature of this event, as well as watching all of you from the dais. Thank you for attending the legal discourse with discipline and for your active participation. I conclude. Thank you all once again for making this day so memorable. Have a great day.
Thank you, sir.
1 minute. Before National Anthem, just 1 minute. Some of our students requested His Lordship for training internship in the visitors' room. Immediately, His Lordship has consented. Thank you so much for the students that His Lordship has already consented whenever you want internship in His office, and He will give us. And that's a great presentation and great offer that we have received this time of His visit. I extend my sincere gratitude for on behalf of the entire students and staff of this institute for your great kindness. Thank you.
I request everyone to please rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request everyone to give standing ovation as our guests leave.
You just stand there and we will take a photo with His Lordship, right? You stand there, His Lordship will be there in the midst, right? Please be there.